Hello there, and welcome. Now, if you've ever even thought about making a personal injury claim here in Scotland, I'll bet you've been absolutely swamped with one particular phrase. Today, we're going to get right behind that slogan, no win, no fee, and find out what it really means for you. Let's get to it.
Aye, of course you have. You can't miss it, can you? It's on the telly, it's on billboards, it's all over every single claims website you click on. And it sounds dead simple, doesn't it? If you don't win your case, you don't pay your solicitor a fee. But is it really that black and white? Well, you know, the truth is always in the wee details.
And that's the real problem, isn't it? It's a fantastic marketing line, but the actual nuts and bolts of how it works are often tucked away in the small print, if they're there at all. It can leave a lot of folk feeling a bit unsure. Well, that stops today. We're going to get right to the bottom of this once and for all.
Right then, first things first. To properly get our heads around this, we need to look at the actual legal setup. And this is crucial, how it's done specifically here in Scotland, because the way they do things south of the border is a completely different kettle of fish. So here's the most important thing to know right off the bat. In Scots law, the proper term isn't no win, no fee. That's just the catchy phrase they use to get your attention. The official legal agreement you'll actually sign is called a speculative fee agreement. And that's not just a different name. It's a specific kind of contract, all regulated properly by the Law Society of Scotland.
And this really gets to the heart of where that name comes from. You see, it's not you who's speculating or taking a punt on the outcome, it's your solicitor. They're the one taking the financial risk on your case. They're putting their time, their effort, their expertise on the line. And if the case doesn't succeed, they get absolutely nothing for all that work. That's the deal.
Now, this is so important. This is exactly why you need a Scottish solicitor for a Scottish claim. Down in England and Wales, they use something different called conditional fee agreements, and their rules on things like success fees are totally different. You just can't apply their way of doing things up here. Our system, run by our own law society, is unique. Local knowledge isn't just a nice wee bonus, it's absolutely essential.
Okay, so we've sorted out the legal lingo. Now let's get to the bit that everybody really wants to know. What happens when you actually win? Where does the money go, and who ends up paying the legal bills?
While in most successful personal injury cases in Scotland, the basic rule is pretty simple and fair. It's called expenses follow success. And it just means that the side that loses is normally ordered to pay a contribution towards the winner's legal costs. So if you win, the other side's insurance company usually pays your compensation and a big chunk of your solicitor's fees. But here's the big question, isn't it? The amount of money you get back from the other side for your legal fees is based on an official scale. But is that always enough to cover the entire bill for all the work your solicitor has put in? And the honest answer is, well, not always. In fact, there's often a wee gap, what we call a shortfall, between the costs paid by the loser and your solicitor's final bill. Now, how that shortfall is handled is one of the most critical parts of the agreement you sign. It really can vary.
Let's just look at this chart to make it really clear. Say you're awarded £10,000 in compensation. Great, but under some agreements, a part of that might be deducted to cover that shortfall we were just talking about. So in this example, that's £1,000, meaning £9,000 comes to you. This is exactly the kind of thing you need to be 100% clear on before you agree to anything.
Right. We've talked about what happens if you win. But what about the other side of the coin? The no-win part. What about the risk of having to pay the other side's legal fees if you lose? How are you protected from that? Well, let's talk about your safety net.
This protection is a special type of insurance called after-the-event insurance, or ATE for short. It's a policy that's taken out after the accident has already happened, and it has one single job: to cover the other side's legal costs if your claim doesn't succeed. It's the key thing that makes the whole arrangement genuinely risk-free for you.
So how does it work? It's pretty clever, actually. First, the policy is set up to cover you. The brilliant part is that the premium is deferred, which just means you pay nothing up front. If you end up losing, the insurer pays the other side's costs, and you usually don't have to pay the premium. If you win, the premium then gets paid out of the settlement money. It's a neat system that gives you real peace of mind.
Now, this is another one of those details that's absolutely vital to understand. What do we actually mean by winning and losing? A win is simple enough. It means you get some money. A loss, though, can be a bit more complicated. It's not just about getting nothing. Pay close attention to this last point. You can also lose if you turn down a formal settlement offer. It's called a tender in Scotland, and then the court awards you less than that offer.
That's a really tricky situation, because you could then be on the hook for legal costs from that point on.
Okay, we have covered a huge amount of ground here. The right legal terms, how the money works, the insurance that keeps you safe. So now let's put all that knowledge to work and put the power firmly back where it belongs, with you. This is all about giving you the confidence to ask the right questions.
I want you to think of this as your non-negotiable checklist. Before you even think about signing a speculative fee agreement, you must have clear, simple answers to every single one of these questions. Will any money be taken from my compensation? Is that ATE insurance included? What happens if I say no to a tender? And is my solicitor actually regulated here in Scotland? These are the absolute keys to making sure you're getting a fair and safe deal.
So let's just pull it all together. No win, no fee, or as we should really call it, a speculative fee agreement, is a fantastic system. It means that anyone can get access to justice no matter how much money they have in the bank. It really does work. But the one key that unlocks it all for you, safely, is your own understanding.
Because at the end of the day, that's what this is all about. It's not about making you a legal expert overnight. It's about giving you the power to ask the important questions, to protect yourself, and to make sure you're treated fairly. And now, you've got that knowledge. You're ready.